Hello, everybody, and welcome. It's Friday, and I'm Gina here again with another episode of Ask Me Anything. And this week, we've got some questions about what do you do when the named trustee or named executor isn't doing what you believe they're supposed to do. In other words, they're not honoring the decedent's wishes. For example, maybe you believe that certain sum of money or a residence or a particular property was to be given to a certain person, a brother or a sister, a child, whoever it may be, and you believe that the trustee or the executor who is in charge of administering the decedent's estate is not doing what you believe is supposed to happen. Basically, what do you do? Well, first I want to address the difference between an executor and a trustee. An executor is the person that manages the estate after somebody dies. If they die with a will in place, the executor is named by the decedent in their will. So in other words, it's a person that the decedent being the person that passes away, it's a person chosen by that person, the person that dies. So it's their choice. It's who they believe and who they want to be handling their affairs and handling their estates and handling the distribution. It's a person chosen by the person who has passed away and named as the executor then in that person's will. So that's what an executor is. And an executor has a fiduciary duty to the estate. They have a duty to follow what the decedent's wishes and desires and directions are. That's their duty. They cannot act in accordance with what they personally want or how they personally feel. They have a job to do, and that is to honor what the decedent has left for them, to do the job that the decedent has left for them. A trustee, on the other hand, is also a fiduciary in that their obligation is similar to an executor and that their obligation is to the estate. And their obligation is to the decedent, the person that passed away. Now, a trustee, though, is somebody that is named by the decedent in a trust document, in a separate trust agreement, and named in that form to then manage whatever part of the decedent's estate, whatever part of their assets, whatever it is that they left in that particular trust. And in accordance with the instructions and the guidelines set out in the trust. So these are different names. They get confused often, I think, among people, but an executor is the person that is named in a will. A trustee is the person that is named in a trust. Either way, both people are chosen by the person that passes away to act in their shoes and on their behalf and to administer their property and their estates in accordance with their instructions and their guidelines. So what happens if these people aren't doing their job, right? Like that's the basic question. And this does happen. They don't always do their job. One time I was out somewhere and quite frankly, there was somebody there who is a professional fiduciary and said right to my face, what's the big deal being a fiduciary? It doesn't matter. Like just gave the role no credit or weight at all, which I thought was pretty appalling because to be a fiduciary is a very big responsibility. Again, it means that you have to act on behalf of someone or something, being the estate, someone else, and in their best interest, not in your own best interest. So it is a very important job. And there are those two different roles, a trustee and an executor, for performing that job. So what happens when you think that they're not performing their job? My first recommendation to everybody is, if you can, get the documents because you might have a misunderstanding. You might not actually know really clearly what the decedent's instructions were and what their guidance was. So first and foremost, my recommendation is get a copy of a will, get a copy of the trust, and see what those instructions were. See if you're correct. All right. And then compare it to the current reality of what's actually happening. Now, let's just assume that you are correct and this person is not doing their job. What do you do then? Well, I like for families to avoid conflict as much as possible, or at least reach peaceful resolutions. And I like for families to try to stay out of court as much as possible. So of course, my first or second, I should say, recommendation then is that you try to talk, you try to have a meeting. You have a meeting with the fiduciary, you address it, you have a nice conversation and figure out what's going on. What is it from their perspective? Maybe there's something more to it that you're missing, but what is it from their perspective that is getting in the way of them doing what you believe that they are obligated to do? And if that basic conversation doesn't work, maybe then at that point, you involve a lawyer or you involve a mediator and you do it in a little bit more of a formal setting. Again, I like to stay out of court for families, so I'm going to recommend mediation if at all possible. I think mediation is a great tool to resolve conflict. It puts the control and the power in the people's hands, the people that are the subject of the conflict. And you can come up really with the terms of your own resolution and your own agreement. You can go as quickly or as slow as you need to. You're not under the pressures of the court. You're not under anybody else's agenda. You don't have all the kind of court filing fees, et cetera. So there's a lot of benefits in mediation. It's an opportunity for two people or more to come together when they're on opposite sides of a conflict and see if you could reach a resolution between you that's going to work. And generally speaking, resolutions reached through mediation are longer lasting because there's more buy-in. When people reach an agreement and they feel like they reached the agreement of their own volition, they don't feel like they were forced into it, which often happens when you're part of the court process, then people are much more likely to follow the terms of that agreement and not take issue with it because they're more invested. So, of course, my recommendation is going to be, if necessary, try to mediate the issue, bring in some other professionals that can assist. And if all else fails and that doesn't work, then of course, court is an option. There are different ways that you can bring the matter before the court. Again, a fiduciary is an important role. That person is appointed by the decedent. And so what they have to do is very specific, and their authority is given to them by statute. So if they're not doing it, then the court has jurisdiction and the court has authority to remove them, to fine them, to do all sorts of things. So if you need to do it, then you don't have a choice, but you go to court and you bring it before the court and let the court handle the issue for you. Above all else, my suggestion would be don't delay. Don't let something like this go on and on and on. The quicker you can address a conflict, the better off you are, just in general. So if you start to get a sense of things not going in the way that you think they're supposed to, go, then don't delay. Reach out to that trustee right away. Start doing the legwork. Try to get the documents, review the documents, see if it is what you think it is, and go from there. So again, in sum, what do you do when the person's not doing the job that you think that they're obligated and required to do, and they're not acting in the best interests of the estate as was designed and set forth for them by the decedent? What do you do? First, talk to them. First, get the documents. First, get the documents. Second, talk to them. See what's going on. Maybe you're missing something, okay? Third, if you have to, maybe involve some professionals. Try to do mediation as a way of conflict resolution. And fourth, if all else fails, you've got no other choice, then I would recommend that you have to go to court. You have to go to court. You have to bring a petition in court. You have to hire a lawyer to do that and go forward. And these things happen. Unfortunately, these things do happen. So it's important to stay on top of it. And I thank you for the question. I hope that I answered it well enough for you. And please keep your questions coming. You're free to email me, GinaMarie@DePrimaLaw.com. Send me a direct message through Facebook, message me through Instagram. Anyway, that's convenient for you. Let me know what's going on in your life, what questions and concerns you have, legal questions and concerns that you may have, or even financial, and I'll address them on our Fridays. Ask Me Anything. Have a great weekend.